Very good evening to all of you, friends. A very good evening to all of you. Welcome to BYJU'S Exam Prep, the most comprehensive preparation app for all exams. Friends, today I bring to you a very important session wherein I'm going to discuss with you not only certain very important multiple choice question insofar as legal knowledge is concerned, but apart from that we are going to discuss about three very important legal development. Number one, Chief Justice of India, Justice U. Lalit, has retired. It's a very important legal development from the point of view of your examination. Now, who is the next Chief Justice of India? Absolutely right. It is Justice D.Y. Chandrachud. Justice D.Y. Chandrachud becomes the 50th Chief Justice of India. He shall have a very good tenure of around 2 years. Apart from that, I'm also going to discuss some very important judgment. That is, the Supreme Court of India has finally upheld the validity of the 103rd constitutional amendment, and after a period of 4 years, the government of India has appointed a Law Commission of India. Justice Ritu Raj Awasthi has been appointed as the chairperson of the Law Commission of India. So these are the three important legal developments that I shall be discussing with you in the course of this particular session. So a very good evening to all of you. A very good evening to all of you, friends. Okay, welcome to BYJU'S Exam Prep, the most comprehensive preparation app for all exam. The first important legal development comes from the Chief Justice's office itself. Justice U. Lalit retires as the 49th Chief Justice of India. He had a very short term of 74 days as the Chief Justice of India. Now, Justice Lalit was an advocate on record. He later on became a senior advocate, and then he was asked by the then Chief Justice of India, Justice R.M. Lodha, to become a judge of the Supreme Court of India. Having a roaring practice at the bar, Justice U. Lalit left his role as a lawyer and adorned the office of a judge of the Supreme Court. Finally, he rose to become the Chief Justice of India. He is the second Chief Justice of India after Justice S.M. Sikri to have been directly elevated as a judge of the Supreme Court from the bar and has held the office of the Chief Justice of India. So the first lawyer, a direct appointee from the bar to the Supreme Court to become the Chief Justice of India, was Justice S.M. Sikri. And the second is Justice Uday Umesh Lalit. Now, after Justice Lalit retires, the next Chief Justice of India will be Justice D.Y. Chandrachud. Justice D.Y. Chandrachud is a brilliant judge of the Supreme Court. He hails from the Bombay High Court. He has a great legal acumen. He is a pass out of Harvard, and he is also the son of the former Chief Justice of India, Justice Yashwant Chandrachud, Justice Y.V. Chandrachud. So, Justice Dhananjay Chandrachud, the son of the former Chief Justice of India, Justice YV Chandrachud becomes the next Chief Justice of India. So in your CLAT examination or in your ALET examination, if you are asked this particular question that who is the Chief Justice of India, should your answer be Justice UU Lalit? No, it should be Justice DY Chandrachud. Is that clear? Now, in this short tenure of 74 days as the Chief Justice of India, he has given a lot of reforms insofar as the judicial side is concerned. Now, a number of hearings, a number of cases were lying dormant for a number of years. Now, these issues related to politically sensitive issues like demonetization, economically weaker section quota, 103rd constitutional amendment, the Citizenship Amendment Act, and the electoral bond controversy. So there were a number of politically sensitive cases that were being there in the cold storage for some time now. Chief Justice retired Justice Lalit made it a point to take those matters up and hear them. He should also be remembered for that historic step that he has taken insofar as live streaming of hearings of constitutional bench matters are concerned. Now, during his tenure, we have seen a number of important constitutional bench hearings taking place. Every day there was one or the other constitutional bench hearing going on. So he made it a point that all these constitutional bench matters be live streamed for people at large, for the society at large, for the people at large to hear and listen to what is being argued in the court itself. Moving on. Now, there are certain very important things that I wish to discuss with you insofar as the office of the Chief Justice is concerned. What does the Constitution say? Now, Article 124, subclause 2 simply says of the Indian Constitution, very categorically states that every judge of the Supreme Court, now this is very, very important, every judge of the Supreme Court shall be appointed by the President under his hand and seal after consultation with such of the judges of the Supreme Court and of the High Court in the states as the President may deem necessary for the purpose. So, Article 124, subclause 2 very categorically states that a judge of the Supreme Court is to be appointed by the President itself. So the President of India appoints every judge of the Supreme Court, including the Chief Justice of India, in consultation with other judges. Now, today the system of appointment of judges is called the collegium system. Okay, now there was a great initiative by in the year 2014 by the government of India to introduce a Judicial Appointments Commission Act, but unfortunately that law was struck down by the Supreme Court, by a constitution bench of the Supreme Court, whereby the Supreme Court said that this law, which relates to the procedure of appointment of judges, violates independence of the judiciary, primacy of the judiciary insofar as appointment of judges are concerned, and therefore hits the basic structure of the Indian Constitution. So as on today, the manner, the process or the procedure that is followed insofar as appointment of every judge of the High Court and Supreme Court is concerned is called the collegium system. Is that clear to each and every one? Is that clear to each and every one of you? Okay, so guys, if you are liking this session, do share this session amongst your friends, because these are very, very important session, very important session, which is going to help you in understanding legal developments. And these classes are absolutely important for whosoever is preparing for CLAT and other law entrance examination. Okay, moving ahead. The next important development, a landmark judgment. The validity of the 103rd constitutional amendment. Okay, this is, I think there's a typographical error, okay, over here. Okay, now the 103rd constitutional amendment, which was brought by the parliament to amend the Indian constitution, whereby a 10% reservation was introduced for the economically weaker section. Okay, so the 103rd constitutional amendment, 103rd constitutional amendment provides for a 10% reservation to EWS, economically weaker section of the society. Now, what is this economically weaker section of the society? Now, under Article 15 and Article 16, okay, Article 15 and Article 16, backward classes of the country, backward classes of the society is provided with reservation insofar as education institutions and public employment is concerned. So both in education institution, be it CLAT, be it any schools or colleges, there is reservation for the backward classes of the society. Now that is provided under Article 15. Whereas Article 16 deals with providing reservation in public employment. Now, by virtue of the 103rd constitutional amendment, a 10% reservation was introduced for the economically weaker section of the society insofar as educational institutions and public employment is concerned. Now, the Supreme Court had to decide on the validity of this particular 103rd constitutional amendment. Now, this amendment was challenged in the Supreme Court, and since this was a very, very important issue, a 5-judge bench finally decided. Now, there is one very important thing that you must remember, is that 3 judges of the Supreme Court, Justice Dinesh Maheshwari, Justice Bela Trivedi, and Justice J.B. Pardiwal, has held that the 103rd constitutional amendment is valid. It is valid. Chief Justice U.U. Lalit, along with Justice Ravinder Bhatt, has held that it is invalid. Okay, so 3 judges versus 2 judges. 3 judges say that this 103rd constitutional amendment is valid, it is constitutional, it does not violate the basic structure of the Indian Constitution. Whereas the Chief Justice of India, along with Justice Ravinder Bhatt, has categorically stated that this 103rd constitutional amendment is violative of the basic structure of the Indian Constitution and hereby has quashed this particular law that was made to amend the Indian Constitution. So in crux, क्या मैं बोलना चाहता हूं कि 103rd constitutional amendment गवर्नमेंट लाया था टू प्रोवाइड, क्या प्रोवाइड करने के लिए, 10% reservation to the economically weaker section of the society. insofar as education institution and public employment is concerned. ये जो कॉन्स्टिट्यूशनल अमेंडमेंट था ये चैलेंज हुआ था इन द सुप्रीम कोर्ट. 5 जज बेंच, कॉन्स्टिट्यूशन बेंच इसका सुनवाई कर रहे थे. 3 जज ने बोला कि ये जो अमेंडमेंट है इट इज वैलिड, ये अमेंडमेंट सही है. 2 जज, जिसमें एक था चीफ जस्टिस यू ललित और दूसरे थे जस्टिस रविंदर भट्ट. जस्टिस रविंदर भट्ट और जस्टिस यू ललित ने कहा कि ये जो कॉन्स्टिट्यूशनल अमेंडमेंट है इट इज वायोलेटिव ऑफ द बेसिक स्ट्रक्चर ऑफ द इंडियन कॉन्स्टिट्यूशन एंड हेंस they have struck the constitutional amendment down. Is that clear to each and every one of you? Am I clear to each and every one of you? Please tell me. Any doubt? So guys, if you're liking this session, do press the like button. If you're liking this session, do press the like button. Okay. Now, I would now want you to go through what the judges have said. Justice Dinesh Maheshwari said, reservation is an instrument of affirmative action by the state so as to ensure all inclusive march towards the goal of an egalitarian society while countenance inequalities. It is an instrument. Reservation is an instrument not only for inclusion of socially and educationally backward classes to the mainstream of the society, but also for the inclusion of any class or section so disadvantageous to the answering the description of the weaker section. In this background, reservation structured singularity on economic criteria does not violate any essential features of the Constitution of India. So Justice Dinesh Maheshwari, who has given the majority judgment, has very categorically stated that this reservation, which is based on providing reservation to people belonging to EWS, economically weaker section, does not violate the basic features or the essential features of the Constitution of India. It does not cause any damage to the basic structure of the Constitution of India. Is that clear? तो हम लोग जो रिजर्वेशन करते हैं इट इज एन इंस्ट्रूमेंट कि जो लोग पिछड़े हैं उन लोगों को आगे बढ़ने के लिए the people who have been left behind, they should be brought to the mainstream of the society. This is an inclusive process so that people who are in a disadvantageous position can come and be a part of the mainstream of the society. Is that clear, everyone? Apart from that, Justice Dinesh Maheshwari has also said that reservation for economically weaker section of the citizen up to 10% in addition to the existing reservation does not violate the essential features of the Constitution of India. It does not cause any damage to the basic structure of the Constitution, because in Indira Sahane versus Union of India, I'm sure that you guys are aware of. So there's also a constitutional bench judgment of the Supreme Court, which is Indira Sahane versus Union of India. In Indira Sahane versus Union of India, the Supreme Court held that the maximum reservation can be 50%. Maximum reservation can be 50%. So Indira Sahane, in Indira Sahane versus Union of India, maximum reservation can only be 50%. Now, when you add the 10% to the existing reservation, it breaches that. But the 3-judge who has upheld the Constitution bench judgment has very categorically said that this ceiling, it is not inflexible. That means it is flexible. And it does not cause any damage to the basic feature of the Indian Constitution when that threshold limit is breached. Is that clear? Is that clear? Everyone. Every one of you. Is that clear? Okay. Let's see what the other judges have said. Justice Bela Trivedi. Justice Bela Trivedi says that, however, now she says that it's 75 years of India's independence and there is a requirement to revisit this system of reservation for the interest of the society as a whole. Justice Trivedi says that we need to revisit the system of reservation in the larger interest of the society as a whole, as a step towards transformative constitutionalism. So Justice Trivedi, in this particular judgment has very categorically said that it is absolutely important that after 75 years, we require to revisit. देखना हम लोग को पड़ेगा कि कैसे हम लोग का रिजर्वेशन सिस्टम है. It is high time that the government of India revisit. देखिए, वोट बैंक पॉलिटिक्स होता रहता है for reservation. Every political party which comes to power wants vote. But vote पॉलिटिक्स छोड़ के भी हम लोग एक ग्रेट इंडिपेंडेंस सेलिब्रेट कर रहे. 75 years of our independence. Do we not require to revisit this system? Now let's see what Justice J.B. Pardiwal has said. Justice Pardiwal says, now why am I bringing you all these things? Because you might get all these things in your question paper itself, because these are all in CLAT. It's all about passage based questions. You might get these passages in your question paper. So if you have understanding of what these 5 judges have said, and if a question comes, it becomes a smoothie for you. Okay. Let's read what Justice Pardiwal has said. The real solution, however, lies in eliminating the cause that have led to the social, educational, economic backwardness of the weaker section of the community. ये social, educational और economic backwardness क्यों आया है? Caste system. This exercise of eliminating the cause started immediately after the independence, almost 7 decades back, and it still continues. So Justice Pardiwal laments that the system, which should have stopped after the constitution coming into force, it has existed and it still continues even after 75 years of India's independence. The long-standing development and the spread of education have resulted in trapping the gap between the classes to a considerable extent, as larger percentage of backward class members. Now, this is very, very important. As larger percentage of backward classes members attain acceptability standard of education and employment, they should be removed from the backwardness criteria. So Justice Pardiwal इधर बोलना चाहते हैं कि जब backward लोग आगे बढ़ जाते हैं, when they come out of backwardness, reservation should not be provided to them. It's talking about the creamy layer. so that the attention can be paid forward to those classes which genuinely need help. जिन लोगों को जरूरत है उन लोगों को रिजर्वेशन दीजिए, जिन लोगों को चाहिए नहीं उन लोगों को मत दीजिए. He further adds that in such circumstances, it is very much necessary to take into review the method of identification and the ways of determining the backward classes, and also ascertain whether the criteria adopted or applied for the classification of backward is relevant in today's condition. The idea of Baba Sahab Ambedkar was to bring social harmony by introducing reservation only for 10 years. However, it has continued past 7 decades. Reservation should not continue for an indefinite period of time, so as to become a vested interest. That means he is talking about politics. Now, आजकल politics के चक्कर में reservation को और 5 साल और 10 साल बढ़ाया जाता है. Baba Sahab Ambedkar, who was the founder, one of the framers of the Indian Constitution, only said that this reservation should continue for only 10 years. But even after 7 decades, we see reservation in our society. Now let's see what those 2 judges who dissented said. Now, Justice U. Lalit and Justice Ravinder Bhatt said that economic criteria is permissible insofar as access to public good. The same is not true for Article 16. That means आप reservation on the basis of economic criteria दे सकते हैं, but educations में दे सकते हैं, but not in public employment. Now, the judge also says that this court has, for the first time in 7 decades of the republic, sanctioned an exclusion. Now, government of India, ये बहुत ही important चीज है, आप सभी को समझना पड़ेगा. जस्टिस यू ललित और जस्टिस रविंदर भट्ट ने यही कहा है कि the 103rd constitutional amendment, the EWS reservation very categorically says that this EWS reservation is not applicable to SCs, STs and OBCs. Those who are already covered, this particular EWS reservation will not be applicable to them. Now, it is for the first time that a reservation is made which excludes a class of people. जस्टिस यू ललित और जस्टिस रविंदर भट्ट यही कहना चाहता है कि ऐसा कोई रिजर्वेशन गवर्नमेंट बना रहे जहां एससी एसटी को बाहर किया गया है. Now, if EWS category reservation should be open to all, which includes SC, STs and OBCs. Now, the government law, the 103rd constitutional amendment, very specifically specifies that SC, ST, OBCs are excluded from EWS reservation. So, the exclusion of the backward classes insofar as EWS reservation mentioned under the 103rd constitutional amendment is concerned is discriminatory and hence it violates. The amendment which excludes the SC, ST, OBC from the EWS category violates the principles of justice and the basic structure. Is that clear to each and every one of you? Is that clear to each and every one of you? Yeah, it is by a 3:2 majority, okay? Okay, Sneha, I'll answer your question in some time. Okay, let's move ahead. The third important legal development. After a span of 4 years, the central government has finally constituted the Law Commission of India. The central government has appointed former Chief Justice of the Karnataka High Court, Justice Ritu Raj Awasthi as the chairperson of the Law Commission of India. So finally, the central government has appointed former Chief Justice of Karnataka, Justice Ritu Raj Awasthi as a chairperson of the Law Commission of India. Now, the central government has constituted this law commission after a gap of 4 years. Very, very important. Former Judge of Kerala High Court, Justice K.T. Shankaran, Professor Anand Palwal, Professor D.P. Verma, Professor Raka Arya, and Sri M. Kurunanithy has been appointed as members of the Law Commission of India. So, the chairperson of the Law Commission of India has been appointed very recently, and he happens to be none other than the former Chief Justice of the Karnataka High Court, Chief Justice Ritu Raj Awasthi. He is the chairperson of the Law Commission of India. Very, very important development, guys. Very, very important developments. आप सभी को Justice Ritu Raj Awasthi का नाम याद करना चाहिए, क्योंकि Law Commission of India has been appointed, a new chairman has been appointed after a span of 4 years. Okay, is that clear? Now, let's understand certain important things about the Law Commission of India. The Law Commission of India is established as an advisory body to the Ministry of Law and Justice insofar as legal reforms is concerned. Let's see. Now, on a reference made to it by the central government or by a suo motu cognizance, it undertakes certain research on law and review existing laws in India. It recommends the enactment of new laws that is required for the implementation of directive principles of state policy and to achieve the objective of the constitution that is formulated under the preamble. It gives its views on matters relating to law and judicial administration that is referred to it by the law ministry. Now, the recommendations of the commission is not binding on the government. Very, very important. जो recommendation law commission देते हैं to the central government, to the law ministry, it is up to the law ministry or the central government whether to accept those or to reject them. Those recommendations are not binding on the government. Is that clear? Yes. Okay. Is that clear to each and every one of you? Okay. Now, before we move ahead with the multiple choice question, BYJU'S Exam Prep brings to you BYJU'S Exam Prep Test Series. Very, very important. With a few weeks to go for CLAT, it's absolutely important that you get this test series. In this test series, what do you get? 45 marks, 20 CLAT, 25 non-CLAT, 9,000 practice questions, tests which covers every subtopics, open mocks with video solution, detailed mock analysis. These are created by NLU alumni and these are based on actual exam pattern. तो आप सभी को जिसको ace करना है CLAT and other law entrance examination, do get the BYJU'S Exam Prep Test Series. Let's start. Which of the following bill granted statutory status to family courts set up in Himachal Pradesh and Nagaland? Family court. Very important and very easy. Family courts amendment bill, district courts bill, trial courts bill, marriage courts bill. Family courts bill. आपको इतना easy question शायद कोई देगा. The Lok Sabha in the year 2022 passed the Family Courts Amendment Bill and granted statutory status to family courts in Himachal Pradesh and Nagaland. Very, very important. Okay, very, very important. Moving on to the next question. A Family Courts Act was enacted to set up family courts in every district. Under this act, state governments are mandated to set up family courts in every city town with a population of more than 1 million. 10 लाख के ऊपर जहां population है वहां family court होना चाहिए. The question is, in which of the following year was Family Courts Act enacted? Okay, I'm sure one hint, much before you were born. Of course, the options are 1984, 1983, 1982 and 1981. Tell me the correct answer. The correct answer is the Family Courts Act came to be implemented in the year 1984. Okay, so Family Courts Act 1984. Very, very important. Very, very important, guys. Family Courts Act was enacted in the year 1984, aimed at setting family courts in every district. The state government is mandated to have a family court in every city or in every town where there is a population of more than 1 million, that is 10 lakh. Is that clear, everyone? Question number 3. Which of the following bills have been passed by the parliament on anti-doping? This helps in establishing a national board of anti-doping in sports. Is it National Anti-Doping Bill 2022? Is it International Anti-Doping Bill 2022? State Anti-Doping Bill 2022? Or Central Anti-Doping Bill 2022? And the correct answer is, let's see, fast. Okay, the correct answer is National Anti-Doping Bill 2022. This establishes a national board of anti-doping in sports. Very, very important, okay? This was introduced in 2022, very recently, and is passed in the Lok Sabha to curb this kind of doping activities in sports. Okay. Who among the following is the current Union Sports Minister? Sports Minister. Maneka Gandhi, Smriti Irani, Rajnath Singh, Anurag Thakur. Maneka Gandhi is not a minister as of now. No. Smriti Irani, Rajnath Singh, no. The correct answer is Mr. Anurag Thakur. Mr. Anurag Thakur happens to be the Union Sports Minister as on today. Okay. Now, this National Anti-Doping Bill was introduced by Anurag Thakur in himself. Okay, that's why this question. And these are certain very recent developments, all happening in 2022. All happening in 2022, and that's the reason these are very, very important for you. Okay. Moving on. Which of the following bills were passed in the parliament to ban funding on weapons of mass destruction? Now, this bill has been directed by External Affairs Minister Shri S. Jaishankar. Okay. Which of the following? Now, weapon of mass destruction, there is a ban. Okay. WMD. Weapons of mass destruction is banned under which law? The correct answer is Weapon of Mass Destruction and Their Delivery System Amendment Bill 2022. So we are talking about very, very recent legal developments, friends. We are talking about very, very recent developments. And I want each and every one of you to pay a lot of attention to these sessions, because these sessions will definitely help you a lot insofar as your understanding of legal developments is concerned. Okay, so Weapons of Mass Destruction and Their Delivery System Amendment Bill 2022 was passed to ban funding of weapons of mass destruction. This was introduced by Shri S. Jaishankar, the Minister for External Affairs. Before moving ahead with the next set of MCQs, there are It's not yet over. A couple of more MCQs, okay? So guys, stay along. Guys, BYJU'S exam prep brings to you a last lap to CLAT 2022. 25 power-packed sessions, must-do topics, practice question based on exam pattern and paper solving skills. It starts from the 5th of November at 9 p.m. I'm sure this is free. All you need to do is just stick to our YouTube channel, okay? And you will get this course free of cost. Now, these are the sessions. On 5th, we already had contract law, 6th, criminal law, 7th, current affairs, 9th, ratio-based caselet, 11th, main idea style, tone of RC, 13th, current affairs, 14th, assumption and inference. So you all have these sessions coming up, okay? The timing, just you can take a snapshot of it so that you do not forget this. A BYJU'S exam prep also brings to you an all India open mega mock for ELIT. 5th to 12th of November. Those of you who haven't, please attempt it today itself. 12th is the last day. It has already begun. The All India Open mock test for ELIT. Okay. Let's get back. Which of the following bills was approved by the Union Cabinet and will now be presented in the ongoing monsoon session of the Parliament? The bill seeks to make Competition Commission of India more flexible and accountable. It is none other than, now it happened in 2022. Some little bit of common sense, you have the answer on your screen. Competition Amendment Bill 2022. These are all very recent developments. As I said, that most of these things have happened in this particular year of 2022. The Competition Amendment Bill 2022 has been approved by the Union Cabinet and will be produced in the monsoon session of the Parliament. It seeks to make the Competition Commission more flexible and accountable. Moving on to the next question. Which of the following bills was presented in the Lok Sabha to convert the National Rail and Transportation Unit, NTRI, into Gati Shakti Vishwasvidyalaya, GVS? It is very important. I'm sure that you must have heard about this Central University Amendment Bill. Okay, this comes under the Central University Amendment Bill. Am I clear, everyone? Everyone, is that clear? So if you are missing a question, go through this video once again and definitely go through today's video again and again, at least twice or thrice, so that today I'm discussing very, very important things, okay? The Central University Amendment Bill was passed in Lok Sabha to convert National Rail and Transportation Institute into Gati Shakti Vishwavidyalaya. NTRI is currently deemed to be university, while Gati Shakti Vishwavidyalaya will be a central university and will be sponsored and funded by the central government through the Ministry of Railways. Moving on. Lok Sabha has passed the following bill on August 2022, which amends the Wildlife Protection Act of 1972. Now, which bill was passed by the Lok Sabha? Now, it was introduced in the Rajya Sabha. Later on, it was passed in the Lok Sabha. Okay, it is the Wildlife Protection Bill of 2021. Sorry, the Wildlife Protection Bill of 2021 was passed in the Lok Sabha in 2022 and has thereby gone to the President for his royal assent. The Lok Sabha has passed the Amendment Bill of 2022 in 2021 in 2022. to amend the Wildlife Protection Act of 1972. It aims at implementation of Convention of International Trade in Endangered Species of Wild Fauna and Flora. Now, there is a convention on international trade. Now, cheetah or other exotic animals are traded internationally. Now, to stop that, this particular bill has been passed in the Lok Sabha very recently. Moving on. Who amongst is the 14th Vice President of India? Without any other thing, Jagdeep Dhankar. He was the former governor of West Bengal. There was a lot of, he was always in the news because he had a lot of clash with the Chief Minister of West Bengal, Srimati Mamata Banerjee. Okay, I'm sure you must have heard about the governor Jagdeep Dhankar. He is right now the Vice President of India. Okay, yeah. Jagdeep Dhankar is the 14th Vice President of India. Okay, and he's from Rajasthan. Is that clear? He defeated Margaret Alva. Margaret Alva was defeated by Jagdeep Dhankar. Okay, defeated. He defeated. Okay, in the election. In exercise of the powers conferred under subclause 2 of 124 of the Constitution, Justice U.U. Lalit was appointed as the 45th, 49th, 47th or 48th Chief Justice of India. Justice U.U. Lalit was the 49th Chief Justice of India, and Justice D.Y. Chandrachud will be the 50th Chief Justice of India. Okay, is that clear? So, Justice U.U. Lalit served as the 49th Chief Justice of India. He took over as the helm of affairs from Justice N.V. Ramana, who demitted office way back in August 2026. And the final question. The Lok Sabha have nod to the New Delhi International Arbitration Center Amendment Bill of 2022. The bill seeks to rename New Delhi Arbitration Center as which of the following? And the correct answer is India International Arbitration Center. This particular bill, now, जो था न्यू दिल्ली इंटरनेशनल आर्बिट्रेशन सेंटर, न्यू दिल्ली को हटा के इंडिया इंटरनेशनल आर्बिट्रेशन सेंटर बनाया गया है. So the correct answer is option A. Okay. The Lok Sabha has changed the name of New Delhi International Arbitration Center to India International Arbitration Center by amending the bill in 2022. Is that clear to each and every one? Okay, I hope you understood. Now, there are a number of important classes that are happening every day. Every day we are coming with an important set of classes on our YouTube platform. You can just take a click of it because all important classes are right now happening on YouTube. So guys, I hope you understand this session. I hope you like this session. Do share this session with your friends and others so that people can get a lot of help from these classes from BYJU'S Exam Prep. Do subscribe to our YouTube channel. Do follow us on our Instagram. Do like our Facebook page. Do join our Telegram channel. And definitely do not forget to download the BYJU'S Exam Prep app. Okay? Thank you. God bless you. All the very best. Bye-bye. Take care. Good night. Take care. Bye-bye. Take care.